Hey, everybody. Welcome. TGIF. It is the Friday night before the first week of Lori Vallow Daybell's trial. And check it out. I've got a ticket. It's almost like a golden ticket, right? Well, maybe not a golden ticket. I'd rather be with Willy Wonka, but I'll be in trial covering it for you all. So welcome. I'm just going to let everybody catch up with join in chat. So we're going to talk about a couple things while we wait. Don't forget, if you are in the Boise area, please join us on Tuesday for pizza and chat over in Meridian at Smoky Mountain Pizzeria Grill. We're going to be hanging out and having a beverage or two and a slice of pizza or two and getting together to visit and chat. You know, I have to say that one of the great advantages or one of the silver linings to getting involved in such an awful case is all of the wonderful people that I've met, both in person and online. So I'm excited that that I'm going to get the opportunity to visit with some of the folks that are local here, and we're going to have a good time. I'm hopeful that we might have a couple special guests and that we'll be able to enjoy some time together before the trial really starts in earnest. Now, jury selection starts on Monday, and that is going to be broadcast from the courtroom to the overflow room. So there will be no public seating in the courtroom itself. And that's because the court wants to have control over making sure that jurors' identities are protected and that when they are breaking out into individual sessions to ask individual questions, that they're able to get it on the record and yet still preserve the jurors' privacy. So folks who are attending will be sitting in the overflow room, and the information will be televised into the overflow room from the courtroom. So there have been a lot of, first of all, I want to say that on Wednesday night, we had almost 900 people in chat. That is a record for us. So thanks for everybody that joined us. And I hope we can start hitting that record frequently when we're doing our 2-hour lives on Saturdays. So for those of you who haven't heard yet, once the trial starts, I will be live tweeting from the courtroom. So if you have not followed me on Twitter, please do. It is at Lori Hellis. And that information's in our chat. We'll make sure that it gets out to everybody, but it's just at Lori Hellis. That's the Twitter account where you will find me live tweeting from the courtroom. Gigi from Pretty Lies and Alibis will also be there and be live tweeting from the courtroom, so you can follow her as well. I will be doing short videos from court, probably in the mornings and then at lunchtime and then right after court lets out, giving everybody a quick update on what's happened. And then we will do a 2-hour deep dive on Saturdays into and review the entire week of trial. So please, if you have not yet subscribed, please do. Hit the thumbs up because that helps us with YouTube's algorithm. But please subscribe and hit that notification bell so you'll get notified when I do post those YouTube shorts. And, you know, we have a bit to talk about tonight about the issue of the Woodcocks and whether or not they are witnesses. Now, we talked at length about this on Wednesday. I do want to point out that Judge Boyce issued an order that freaked everybody out a little bit, because the order said only witnesses will people who are going to be witnesses will be excluded from the courtroom unless you are a victim, legally considered a victim. Now, I want to point out that that order was issued prior to the judge receiving the written arguments that he asked for from the parties. Rob Wood asked if they could submit written argument. He said, okay, please make sure that it gets, take this down, that it gets to me by Friday. So that order was issued before he has had time to consider the arguments from both sides. Now, you all may have noticed just probably 10 minutes ago, you got a newsletter in your inbox, and that newsletter really goes through the deep dive into whether or not I think Larry and Kay meet the legal definition of immediate family. So you can take a look at that. It will be interesting to see what Judge Boyce does with this. Now, Kay and Larry have hired an attorney who is licensed in Idaho, and that attorney has filed a memorandum in support of Kay and Larry being permitted into the courtroom. It will be interesting to see what Judge Boyce does with this, because in my opinion, they do not meet the statutory definition of a victim or immediate family. I know that that is not a popular thing. Don't shoot the messenger. But what I am saying is that regardless, once Kay and Larry testify, they should be permitted into the courtroom. And I want to make this point. Scott Reich, I love you, but you got it wrong today. This has nothing to do with whether or not Kay and Larry can have reserved seating in the courtroom. There is no doubt that there is going to be room for Kay and Larry to sit in the courtroom and to be present. So anybody who's telling you that this is about whether or not Kay and Larry have to join the reservation system like the rest of us, or whether they have to, whether they have reserved seating, the bottom line is they have reserved seating. They will be allowed to be in the courtroom anytime. They are not excluded because they are testifying. So Rob Wood can resolve this problem very quickly. All he needs to do is call him first. Now, admittedly, that may throw off his chronology or the way that he's would present the case. But in the grand scheme of things, Larry and Kay would likely be pretty close to the beginning anyway, because the story starts with them being concerned about not being able to contact JJ. So I think that this may be much ado about nothing, because I think that Rob Wood can resolve the problem by calling them. Now, some people asked whether or not if they were going to be recalled, if the defense could say, we have to keep them out until they're recalled. I don't think so. If I were in the courtroom, I would argue that whatever Kay and Larry were being called to testify on redirect or on rebuttal, it would be based on their prior testimony. And so it wouldn't make any difference whether they were in the courtroom and had heard other witnesses, because they'd be being questioned about their prior testimony. So I don't think that it is, I don't think that there's as big a deal as some people think it is. Now, I don't want to diminish in any way Kay and Larry's role in this case. Had it not been for Kay and Larry and their questions, we may still not have known where where Tylee and JJ are. They would not be, law enforcement would not have been digging into this case the way they did. So I don't mean at all to minimize Kay and Larry's role in this, because it is beyond significant. But, and I don't want to minimize Jim Archibald's sort of inartful phrasing of, and his sort of insensitivity to the situation. But to be clear, whether Kay and Larry are considered grandparents or whether they're considered aunt and uncle, they still don't meet the definition for immediate family. So that it's kind of a red herring, because in actuality, regardless of whether they are considered grandparents or aunt and uncle, they still don't meet the definition of immediate family. Now, I do want to point out that Jim Archibald made a thing about adoption law. And he said, you know, under Idaho adoption law, their familial rights were terminated. Well, that is the case in every state. So JJ's adoption was finalized in Louisiana, but that's the case in every state. When an adoption is done, it terminates not only the biological parents' rights, but also all of the other familial rights as well. Now, there are not a lot of states where extended family have any kind of rights, but there are some states that recognize grandparent rights or other sorts of familial rights. And in those states, their rights would be terminated as well. So when Kay Woodcock's son, when his parental rights were terminated, that terminated that entire side of the family's any kind of familial rights. Now, there's no question that Lori and Charles invited and encouraged Kay and Larry to continue to take that role as grandparents, to be called Mama and Papa, to be treated as grandparents, and to treat JJ as their grandson, to call him their grandson. There's no question that everyone encouraged that to continue, and it was good for JJ. So, but what Judge Boyce has to decide is the legality, the legal definition, and not the emotional definition. So he's being called to determine who under the law is immediate family. Now, under the law of Idaho, immediate family are spouses, parents, in-laws, and the children and their spouses, adult children and their spouses. Aunt and uncles, grandparents are nowhere on that, siblings, but aunts and uncles and grandparents are nowhere on that list. So no matter how you classify Kay and Larry, they're not exempt. They're not to be considered immediate family of a homicide victim. So Rob Wood made the argument that the statute says victims are anyone who has experienced or been threatened with physical, financial, or emotional abuse or injury. But that's not exactly the way the statute reads. What the statute says that a victim is a person who has directly experienced physical, financial, or emotional harm. So I do not argue that Kay and Larry have experienced emotional harm as a result of Lori's behavior, but they were not the direct victims. Tylee, JJ, and Tammy were the direct victims. Now you say, okay, Lori, but couldn't that be read more broadly? Well, I have to look at the construction of the statute. And in another paragraph, it specifically says the immediate family of a homicide victim are also considered victims. Now, if that paragraph having to say that anybody who experiences emotional, financial, or physical harm is a victim were to be read broadly, you wouldn't need that. You wouldn't need to then allow the immediate family of a homicide victim to be considered victims, because they'd already be considered victims of the emotional distress. So I think if you read the whole statute together, you can see that the legislature intended victim to be that person who is directly impacted. In this case, it is Tylee, JJ, and Tammy. So immediate family, parents, children, siblings, and their spouses of the victims are immediate family, and thereby are victims as well, because the victims are no longer available to exercise their victim rights. So hopefully that makes things a little clearer. I've also had a couple of questions which I am going to answer delicately and carefully. The first question had to do with JJ's biological parents. I cannot imagine the grief, the guilt, the distress that his biological parents must have experienced, knowing that believing that they were doing what was best for JJ, allowed Lori and Charles to adopt JJ. Certainly they could never have known what was coming, but nonetheless, I'm certain that they had a tremendous amount of guilt and distress around it. You may recall that the reason JJ came into state care was because Kay's son, Todd, and his girlfriend, Mandy, were both deep into addiction at the time. Little JJ tested positive for drugs in the hospital. Child welfare got involved. He was placed with Kay and Larry in those child welfare cases, which I used to represent people in all the time. The next step is to provide services to the parents to try and help them get back to the point where they can provide safe, adequate care for their child. In this case, apparently, that wasn't possible for Todd and Mandy, because the state agreed to, I think, initially approached Kay and Larry about adoption. Then when Charles suggested that he and Lori adopt JJ, they were all for it. Understandably, they lived in a large suburban area where there were good services for children with special needs. They already knew JJ had special needs, and so they were all they were all on board with him being in a place where he could get good services. And Charles and Lori were younger, and Lori still had Tylee at home. So there were a lot of advantages to having JJ in their family. At least they perceived that at the time. So now, hindsight being what it is, we realize how incredibly dangerous the situation was and how tragic the outcome was for JJ, for Tylee, and for Tammy. Todd, Kay's son, has recently completed a long term, which is Great. Drug addiction is a very persistent problem, and often people who receive treatment do better in long-term treatment programs rather than 60 days, 90 days. They do better in long-term programs. So my understanding is Todd has finished his long-term program and is in the process of continuing his recovery. And he has had the support from Kay and Larry and from Kresha and from the whole family. Unfortunately, JJ's mother, Mandy, died of a drug overdose last year. And it's very unfortunate that she was not able to respond the same way to treatment that Todd has been able to. So the other question that I have gotten, which I wanted to address, is the issue of whether or not JJ was a ward of the court. He was not. Categorically, JJ was not a ward of the court. Here's what happened. When Kay and Larry discovered that JJ they were concerned about JJ, and at that point didn't know where he was, and had gotten law enforcement involved, and law enforcement was searching, Kay and Larry, probably at the advice of their lawyer, filed an action for guardianship. Made perfect sense, because what that meant was if they were JJ's guardians, he could be placed directly with them and wouldn't have to go into foster care if he were found alive. That guardianship was never granted. There was never a guardianship put in place. It was a pending case. And the idea was that if JJ were found, they would be ready and poised to get that guardianship underway and keep him from having to go into foster care. JJ was never found alive, and the court cannot order a guardianship for someone who's deceased. So there was never a guardianship entered. JJ was never a ward of the court, and there was never anyone who had any right to custody of JJ other than Charles and Lori after the adoption was over. So that hopefully answers that question. We're going to take a few questions now and get to as many as we can before the end of the hour. We've got about a half an hour to start getting through those questions. So I'll just take a little sip here. Hi, Ladybug. Question: is it possible to change the judge before Chad's trial to get cameras back? It is unlikely that the judge will change unless Judge Boyce determines that he needs to be off the case for one reason or another. I don't anticipate that we are going to get a change in judge unless Judge Boyce decides he's either done his time and had enough, or there's some other reason why he should be off the case. Now, it's possible that he could allow cameras for Chad's case because there would be less argument during trial that there would be any prejudice to anybody if he allows it. I don't know. I suspect that he just is going to stick to his guns and not allow cameras in the courtroom. So we're going to do our best to give you as much information as we can from the courtroom, live tweeting and doing short videos on the breaks. Hi, Venus Gal. If they weren't witnesses, they'd be allowed in the way I understand it. It is due to the sequestration of witnesses. So shouldn't even those classified as victims also be sequestered if testifying? This is a great question. Every lawyer will tell you, we want witnesses sequestered. We want witnesses excluded from the trial until they're done testifying. Then we don't care. but we want them out of the courtroom so that they can't compare their testimony with anybody else. But because there are victim rights that are written into the state constitution and into the state statute, that trumps that request from the lawyers to sequester witnesses. So sequestration of witnesses is a procedural rule. Procedural rules are the statutory and constitutional rules take priority over procedural rules. So in this case, because immediate family are considered victims, they can't be kept out of the courtroom. So, for example, if you are in a trial where you have, say, multiple victims who, let's say it's a criminal trial, and you have a person who is directly a victim. Let's say it is just because I don't want to get demonetized, let's say it's an armed robbery, okay? So the person who is the victim, it is the convenience store clerk. Well, in usual circumstances, that clerk would be called as a witness to tell what happened. And in usual circumstances, a witness would be required to be out in the hall. But because victims have special rights, that victim is allowed to sit in the courtroom and to hear the rest of the testimony. It's a balancing thing that the law does in order to allow victims some rights. Now, a lot of this came about in the late 80s, early 90s, when the political pendulum sort of swung the conservative way. And a lot of states came up with mandatory sentencing and a victim's Bill of Rights. Prior to that, it was possible to keep a victim out of the courtroom until they testified. But the victims' rights advocates in most states were able to lobby for the changes to the rules, including writing the rights into the state constitutions in order to make sure that victims' rights were protected. So they had a right to be in the courtroom, to be consulted by the prosecution on any major decisions in the case, to be advised when the person was going to be released on bail, to have a sort of a litany of basic rights to be, so they could feel safe. But that also means that that they get special treatment when it comes to being excluded out of the courtroom. So I understand it doesn't seem equitable, but we have decided that victims are a special class of people, of witnesses, and as a special class of witnesses, they get different treatment. So, good questions. You know, I will say, I said this last week. It's interesting that I was talking to somebody who is one of our followers, and she was saying, you know, it's amazing to me how as time has gone along, the folks in chat have become more legally educated and are asking really kind of deep sort of procedural and legal questions that we all find interesting. And so I think it's exciting when I get those kind of questions that we can really sort of do a little bit of a deep dive on the law. Hello, T Diva. Question: will Kay and Larry be able to lay JJ to rest, or will they have to go to court to do it because they are not the grandparents? So I think this is an interesting question. Understanding probate law, the only person at this point who would have the say-so to determine this would be the legal parent, which would be Lori. Now, certainly the judge is going to certainly any judge is going to say she no longer has the authority to make those decisions. But the question is, who's the next person in line? It seems to me that that next person in line is Colby. And my understanding is that Colby has agreed that Kay and Larry should be the ones to be able to lay Tylee and JJ together to rest. So this is a personal, very private discussion and decision that gets made among the family. Nonetheless, the court will order. Where the court comes in is the issue of when the remains are going to be released. Rob Wood has been adamant that he did not want them released until after the trials. I think that it has gone on long enough, frankly. And I think that Kay and Larry, hopefully joined by Colby, would have every right to go to court and to say, enough's enough. We need to have these children's bodies released so that we can have some closure. And I think it would be more than reasonable for them to want to do that as soon as Lori's trial's over. So I hope that's what will happen. Kay and Larry now have an Idaho lawyer, so I hope they will employ that Idaho lawyer to get involved and hopefully secure the release of the children. So I'm with you. I think it's been long enough. Bavarian Rage. I am absolutely fascinated with how y'all get your screen names, but I can't imagine being rageful in Bavaria. I've been to Bavaria and I loved it, and I can't imagine raging. Are you ready for the insane pace of the next 8 to 10 weeks? What will your daily schedule look like, and what are you doing for self-care? These are great questions. Thank you for asking. Well, I am ready for the pace. It's really been interesting as I've sort of geared back up for this, because I haven't had to go to the courthouse at first thing in the morning for about 3 years. So it's been sort of interesting getting back into sort of thinking about it and getting back into the habit of it. But I'm ready. My schedule will be that I will get up and head for the courthouse. Initially, at least, I will be getting to the courthouse at about 8, just to make sure that I'm there and understand what the mechanism's going to be getting into court and these reservations and tickets and all of that. So I'm going to be initially getting there at about 8 in order to make sure. That also puts me up and probably in line and ready to push the reservation button for the next day, being there by 8. So my plan is then to do a short YouTube live at lunchtime. Hopefully, if the weather permits, get a little walk around downtown to get some fresh air, and then be back in court. The court has been talking about adjourning around 4 o'clock, which would make some sense. But I'll be there until court adjourns and then head home. I'll be doing YouTube shorts as often as I can, certainly at lunch and right after court, catch everybody up on what's happened. We'll be live tweeting and then coming home. I'm hoping that that will still leave me enough time to drop in on my mom, who's just a few minutes away in a retirement place, and then kind of take the evening easy. I'm sure that I will be going over my notes and making sure that I've captured everything from the day before sitting down to relax. But the weekends, I'm going to, other than my 2-hour live on Saturdays, I think I'm going to try and put my feet up a little bit. But I know I watched Gigi do the Murdaugh trial, and I know how grueling it can be. I'm fortunate because it's right here in my hometown, so I am not going to have to travel back and forth. I know Gigi's going to be a week on, a week off, to sort of take some of the stress off of all of that travel back and forth to South Carolina. But it's going to be a lot for her. And it was a lot for her doing Murdaugh and having to make a long drive. So thanks for looking out for me. If I start looking a little weary, you need to tell me. Hooly dooly. Is there leeway legally for Boyce to make his own executive decision with regard to Larry and Kay? Like in this situation, it is obvious Larry and Kay are the types of loved ones entitled to be present. I don't think so. I think that the case law and the statute are pretty clear. But let's remember, this only means that their reserved seats are going to be empty until they come in and testify. And that could be very early in the case. I think Rob would, if the judge orders that they are not immediate family for the purpose of being in the courtroom during trial, I'm certain that Rob Wood and Lindsay Blake will be putting them on soon, quickly, so that they don't miss a lot of the trial. I know. I know it's a huge disappointment for them. I know it was a huge emotional blow for them. I know that it feels like they're continually being victimized. And in some regard, they are. I mean, I can't argue with that. And I would be the last person to say that I know how they feel, because I don't. And I don't know how they feel. All I can do is sympathize with them, let them know that I and all of you all support them, and that no matter what happens in the courtroom, justice is coming. I would be much more concerned if we had some big evidentiary rulings that put a verdict at risk, and that hasn't happened. So I think justice is coming for Tylee and for JJ and for Charles, eventually for Charles and for Tammy. Kathleen Smith, wouldn't Charles' other sons have the same victim status as Colby? As siblings of JJ, yes, they would. Absolutely, they would. I don't believe that they intend to be involved in these cases. That's what I've heard. I'm certain that they may be more interested in being involved in the Arizona case having to do with Charles's death. But because they're half siblings of JJ's, they certainly would have the same victim status as Colby. Janine Carr. So are the witnesses forbidden to listen to the court proceedings via the audio recordings? It seems that it would be impossible to control, and if not, how is that different? It will be very difficult to control, but I'm certain that the judge will be telling them, you cannot be in the courtroom until after you testify, and you cannot listen to the trial until after you testify. Now, how that gets policed? Well, we saw how it happened in the Murdaugh case. It was definitely an honor system, and somebody ratted out the juror who'd been talking to their friends. So, I think it's risky. And knowing Kay and Larry, I don't believe they would do anything that would compromise this case. They want so much for this trial to be over. There is no way they would do anything that would risk compromising the case. So I am convinced if the judge said you may not listen until you testify, that they would not. I'm confident that that would be the case. I don't know them well, but I think I know them well enough to make that prediction. Lee here. Question: is Lori able to hear all Todds jail calls just released to her lawyers? I would say it's likely that she's been able to hear some or all of them. To be honest, because they're not coming in Lori's trial, I'm sure that her attorneys have been focusing on other things as they prepare for trial and prepare her for trial. I'm sure that that hasn't been their priority, but I think it's likely that she will have had access to those calls and been able to listen to them. And perhaps they could be a little bit eye-opening. Good questions. Hi, Bo Peep. Do you think Lori will insist on a speedy trial in Arizona? And if Judge Boyce will move the trial to Ada for Chad's trial? So Chad's trial's already been moved. The venue's already been changed to Ada County. That did not change when the trials were severed. So there is still an order for Chad's trial to happen in Ada County. Judge Boyce would have to do something. He would have to order the case back to Fremont County. I don't see that happening. I don't see that happening for a variety of reasons. But once Lori's already been tried here, then I think I think he will continue to have the cases heard here. So I don't expect that he's going to do anything to move the case back. I don't know whether, sorry, it was just thought maybe I had a text from my mod, so I wanted to double check. I don't know whether Lori will insist on speedy trial in Arizona or not. That will be a tactical decision that she will have to make with her Arizona lawyers. And part of that will depend, I think, on the outcome of the case here in Idaho. If she already has a life in prison without parole or a lengthy sentence here, then it isn't going to do her any good to speed up or not waive her speedy trial in Arizona. She's not going to be in any rush to get those cases adjudicated because she's just going to have to come back to Idaho and serve her sentence here anyway. So I don't think there's the same sense of urgency. Now, in this case, I think Lori honestly believes that she is going to be exonerated and that she's going to be released, and that's why she's in a hurry to get to her trial. I believe her attorneys when they say that she completely and utterly believes that she is going to be found not guilty and she is going to be released. So, if in fact she is convicted and receives a long sentence here, there doesn't seem to be a lot of reason for her to rush to trial in Arizona because she's just going to have to come back to Idaho to serve that sentence anyway. Any sentence that she would receive in Arizona, she would have to serve after she serves her Idaho term. And that could be a very lengthy sentence. So, good questions tonight, guys. Go Shift Pro. Would Kay and Larry be allowed in court for opening statements and just leave when the witnesses started? That's a good question. That is going to depend on Judge Boyce. In trials that I've been in before, people who were interested in hearing opening statements were allowed in the courtroom for opening statements and then asked to leave before the testimony started. But that is going to be a Judge Boyce call because he could say he feels like Lori would be unduly prejudiced by them being able to hear the state's theory of the case. I frankly think that Rob Wood and Lindsay Blake have been talking to them all along about their theory of the case. I think they know a lot more about the evidence in the case and the theory of the case than they have been able to share. And so I don't know that anybody should be overly worried about them sitting in and hearing opening statements, but good question. Andrea D. Is there a way we can contribute to Kay and Larry's expenses during the trial? You're not the first person to have asked this, and I have forwarded that inquiry to Kay, and she hasn't responded. So I guess what I would say is not yet. I'm hoping that I will get the chance to ask her in person sometime next week. And because I know that there are a lot of folks that live here locally that would like to support them. And I know that there are folks all over that would like to contribute to their expenses during the trial. So that is an excellent question, and I will ask Kay when I see her. What is in the wine glass tonight? It is a red blend called Cocoa Bon, which happens to be one of my favorite inexpensive red blends that I buy at Trader Joe's. Now, y'all need to know, I am not a wine connoisseur. My daughter's future father-in-law is a wine expert. He has certifications that only a handful of people in the country have. He is the ultimate wine connoisseur. And every time I visit, I get a lesson, which I thoroughly enjoy. But I do not have the most refined palate in the world, and Roger will tell you that. Although I do like good champagne. Thug Nasty. How confident are you that the prosecution will present a clear and concise argument? Is getting into the weeds of the occult beliefs prerequisite to prove murder, or can facts substantiate? This is a really good question. You guys are getting so darn smart these days. But this is a really good question. And for any of you that watched the Murdaugh case, I think you can see how easy it is to get derailed and to get sort of into the minutia of the case, the weeds, and maybe lose the jury. Now, the Murdaugh case, obviously, they didn't lose the jury, and the jury was right with the prosecution as they went through all of those financial misdeeds. I think this is a good parallel because the financial misdeeds sort of meshed with the murder in the same way that these occult beliefs mesh with the murders here. So I don't know how deeply they will have to go into those beliefs, but I think they will have to go into them, and here's why. As we've said over and over again, the prosecution does not have to prove motive. They only have to prove the elements of the case. It happened in Fremont County. A human being was murdered, and the aggravating factors apply. So there aren't a lot of those issues having to do with the occult or the cult beliefs that really go directly to those elements of the crime. But juries want to know why. For example, the prosecutions really offered, in the Murdaugh case, offered the financial crimes and covering up for the financial crimes as a reason for the murders, as a motive. And so I think likewise in this case, the prosecution is going to get into the cult beliefs in order to give the jury something to grab onto as to why this happened. I think that we're thinking, meaning seeking beings. We are. We're always trying to understand and make sense out of things, to figure out meaning behind things. And so when a jury sits down and they're told this heinous crime happened, this mother killed her children, the first thing any one of them is going to ask is, why? Why would she do that? And although the prosecution doesn't have to prove motive, and they will hammer that home over and over again, we don't have to prove to you why. Ultimately, they're going to have to prove some element of it in order for the jury to grab onto that and say, okay, now I can find beyond a reasonable doubt, because now I understand that maybe there was even if it is a twisted, irrational reason, there still has to be a reason. So while they don't have, the prosecution is going to be trying to present a clear, concise argument on the facts and prove every element of the case. I think what I'll do for next newsletter is to list the elements that they have to prove, and then that way it makes a little more sense. But they have to prove every element. Not only are they going to be doing that, but they're also going to be sort of shaping the story so that the jury begins to understand that there was a why. It may not have been the most rational or sensible whys, and it may not be anything we would understand as a why. I mean, let's face it, killing your wife and your son at the dog kennel because you were stealing money from your partners and your clients, that's not rational. That's not A to B to C to D, right? I mean, that's kind of A to X. But it did give the jury something to say, okay, even though it doesn't make the most sense in the world, I get that there was some reasoning or something that caused him to go there. And so I think the prosecution is going to have to do that same thing in this case and be able to say, okay, here's why they went there. And I think anytime you have a parent who murders their child, whether it's Alec Murdaugh or whether it's Lori Vallow, you have to ask the jury to make that leap when 99.99% of the population are never going to be able to make that leap. We're hardwired to protect and to take care of our children. And so the bulk of us are never going to be able to make that leap. But being able to connect the dots, that's different. So, good question. Purity. Question, will there be audio released after the jury selection? I believe so, to the extent that it is public. So what the court said was some of the jury's questioning will be done in private, and that makes sense because you're asking the jury fairly personal questions about their personal beliefs, and also making sure that if you're asking them any identifying information, that's not coming out. So I believe that you will be able to hear the same things we'll be able to hear in the overflow courtroom, but there will be times when the microphones will be turned off, and the audio will continue to record for the court record, but it won't be made public. So I think you might find it to be a little chopped up and a little bit confusing, because there are going to be times the judge is going to cut the sound. Hopefully that makes sense. LFM. What if the jury wants to visit Daybell's land to see the burial site where Tammy was murdered? It now belongs to a defense attorney. Can the attorney say no? No, because I think the court could order it. It is about a 6-hour drive from Boise out to Fremont County. That's on a good day. And what would happen is they would load the jury up on a bus, and they would drive them out there, and then they would have to drive them back. That's a 6-hour drive out, visit the site, a 6-hour drive back. You're probably talking about 2 days. When put that way to a jury, I suspect the jury is going to say, I think we can get a feel based on the photos, particularly since there are some really good aerial photo views. So I would be very surprised if they asked for a jury view of the property. I think in the Murdoch case, they had a lot more questions about how far the house was from the kennels, the physical layout and space of the kennels. And I think that in that regard, I think that there was a lot more, it was a lot more important to understand the spatial relationships between things, if that makes sense. How big was the feed room? How far away from the feed room was where Maggie was shot? Those are things that probably were helpful for the jury to sort of get a spatial feeling of that. I'm not sure as much of that is relevant in the Daybell case. I've been to the property, and having been to the property and stood on the street and looked at the tree and the area where JJ's body was found, and stood on the street and looked back toward the fire ring, I don't know that it's all that different than what I thought it would be in the photos. So I mean, I hope that helps. I don't know whether the jury would be asking for a jury view. I doubt the defense would be asking, or the prosecution would be asking for a jury view, because I think they're both going to feel like they can do an adequate job with the photos and the descriptions from the law enforcement people, particularly since there are aerial photos. So, did I get my seat yet? I did. And someone was selling one on Twitter. Well, that's not going to go very far, because the court is going to call a screeching halt to that. They're already, in order to get in line, you have to have the email that has your name on it, your government ID, and a ticket. So I think it will be hard to sell them. We were told when we went to that conference that if you had, say, some of the news organizations, if you had someone that was coming to cover in the morning and then they were going to be swapped out by some other person in that office, that they had to email the clerk and let the clerk know who was leaving and who was coming in, to make sure that they were accounted for. So I think they're going to be pretty tight about how those tickets are used. And so I would expect that it would be difficult to sell them on Twitter. They're free. You just have to get up early in the morning. It's interesting. I got up and sat in front of the computer and had to refresh a couple of different times because their system was a little overwhelmed. And at 8:03, they confirmed that they had received my reservation. And then I had to wait to see whether or not I was actually going to get a ticket, but they do tell you what number you are in the queue. So I was the 168th ticket at 3 minutes after 8, if that tells you anything about what the demand has been. Gigi told me she was 160, so she was just a few ahead of me. So I think it's going to be, I think the demand will die down as time goes on. I think the diehards will stick around and the demand will sort of decrease as time goes on. But it means that we'll all be at our computers at 8 o'clock pushing the button until we get our seat. So. Gritty Gret. If Kay and Larry are subject to recall after their testimony, are they then unable to be present at all? See, I don't think so. And if I were the prosecution, I would be arguing not. Because if they're going to be recalled, it's going to be in relation to what they already testified to. It's not like they can go off and make up stuff because their testimony is already kind of locked down. So I wouldn't think so. I would think that once they're done with their direct testimony, then they'll be able to get in the courtroom. Now, Judge Boyce can be picky about things and be a stickler about things, and he could make a different decision. But if I were arguing, I certainly would argue that once they've testified, there's no reason why they shouldn't be in the courtroom. And even if they're going to be recalled, it's going to be recalled for questioning about their testimony. Oh, I thank you for reminding me. Thanks for all the folks who bought me a coffee. I'm going to be well caffeinated on my way to court in the mornings. I appreciate that. For those of you who might be new to the channel or don't know, all of our Super Chat donations, everything that comes in through PayPal, all of those things go directly to our moderators. And so I'm happy to be able to share your generosity with them. But the one thing I haven't shared are my coffees. So thanks for all of you who bought me a coffee. Thanks. I got a lovely card in the mail with a Starbucks card attached. So thanks for that too. Yes, please join me Wednesdays for True Crime Wednesday, although next week we will not be doing True Crime Wednesday, and we will not be doing it until after the trial is over. So coming up, starting next week, we will be our live will be 2 hours on Saturday, where we will be recapping the trial, and we're going to pretty much be focused on Vallow Daybell until this trial is over, and then I look forward to catching up with all the other cases that are out there. One of the cases that I've been very interested in is the University of Idaho student murders Brian Kohberger case. And so I absolutely will be attending his preliminary hearing on June 26th. So already made my reservations for a hotel. So I'll be there. That is scheduled to go all week that week. And I am looking forward to that. Sarah, thank you so much. Wishing me safe travels. And for her compassion as a human. That's very nice of you to say. I hope that we never lose our humanity and lose sight of that as we're dealing with all of these unsavory things. I hope over the years that I have not become too jaded when it comes to these kind of cases. So I want to thank everybody. We have almost 600 in the chat tonight. That's not quite the 900 we had on Wednesday, but that's getting up there. So thanks so much for joining us. Thank you for all your good thoughts. Look for all of my tweets and my communication from the courtroom, and I look forward to letting you know what's going on out of the Ada County Courthouse. starting on Monday. So hopefully you're along for the ride. Good night.